A Wisconsin woman who is currently serving a life sentence for the murder of her former lover is seeking a retrial. Okay, her name is Ezra McKinley's 26, is petitioning the state appearance court after a Dunn County judge announces she would not be granted a new trial for the 2018 stabbing death of Alex Woodworth, 24. The appeal was filed with the Wisconsin Appellate Court by McKinley's defense team. In addition to a trial, they want interview police conduct with Cantless to be excluded from a future legal proceeding that may occur. Y'all like, share, and subscribe. Let's get with our video, okay? Okay, here we go.
K-V-A-N-G. Officer Bang, how are you employed? With the City of Eau Claire Police Department. As a police officer? Yes, sir. How long have you been a police officer? 5 years. All with the Eau Claire Police Department? Yes. Were you working February 26, 2018? I was. Were you dispatched to 1118 State Street, Apartment 2 in Eau Claire? I was. What was the nature of that call? Me and an officer were dispatched there for a person's call. Do you know the person? Do you know who made the call? Yes. Who was that? Joshua Trinkler. And is that, if you recall, Treankler? Yes. Did you speak with Ezra McCandless when you arrived? I did. Is the person you spoke with and identified as Ezra McCandless in the courtroom today? She is. Can you identify where she's located by describing a location and an article of clothing, please? She is sitting at the defense table wearing a pink jacket.
The record will reflect that the witness has identified Ms. McCandless, the defendant.
Thank you. Did you have an opportunity to not only have contact with the defendant, but also speak with her? I did. Where did that discussion initially start? It started on State Street, but then she requested to speak with me at the police department. And so she requested that? Correct. Did you accommodate that request? I did. Did she say why she wanted to go to the police department? She just wanted to speak somewhere in private. How did you and the defendant get to the police department? I drove her in my squad car to the police department.
Yeah, that he said. Yeah, on him. Her boyfriend was on her conscience.
Where within the department was that? Was the defendant being treated as a suspect of any kind? No. What was her role in the call as far as you were concerned at that point? A victim. During that interview, did the defendant describe a number of different incidents to you? She did. And who was the person other than her that was involved in those incidents?
A person by the name of John Hanson.
Now, were there a total of 3 incidents?
Yes.
Let's start with the first incident that she described. Did the defendant say where that occurred?
She did.
Where was that?
At 135 Broadway Street.
Did the defendant tell you approximately when, in relation to the interview, that incident occurred?
About a week prior.
What did the defendant explain to you about what happened during that initial incident?
At the Broadway Street address, she was home at that residence with a John Hanson. There at the kitchen counter, John grabbed Ezra with his right hand.
Now, let's just step back a second. Whose residence was that, if you know?
Jason Mangles.
Did the defendant describe to you the relationship at that time between her and Jason Mangle?
She did.
What was that relationship?
Boyfriend and girlfriend.
Was that both at the time of the incident as well as at the time of the interview?
Yes.
Was Jason Mangle home at the time of the incident as described by the defendant?
No, he was not.
Was there anybody else besides John Hanson and the defendant at the Broadway Street address, according to the defendant, when the incident occurred?
No one else was home.
You said it started at the kitchen counter, is that correct?
Yes.
And you said that the defendant stated John Hanson grabbed her by the throat, is that right?
Yes.
Did the defendant describe what John Hanson did while grabbing her by the throat, according to her?
That he squeezed her throat, which caused her pain, had a hard time breathing, and caused her to cough.
Did the defendant tell you whether or not she told John Hanson to stop?
She did not.
She did not tell you, or she did not tell him?
She did not tell him.
Did she tell you whether or not she tried to fight John Hanson off?
She told me she did not.
Did the defendant tell you what she did immediately after John Hanson, according to her, grabbed her by the throat?
She placed her hands on his wrist.
Did she push herself away or back away?
She told me she did not.
What did, according to the defendant, John Hanson do next?
He released his grip, and then she backed away, and then he put her in a headlock.
Oh.
According to the defendant, what did she do next?
She did not fight back, and she only put her hands up.
According to the defendant, did John Hanson release her?
He did.
And according to the defendant, what did she do?
She went and sat down on a couch.
Again, according to the defendant, what did John Hanson do at that point?
He acted like nothing happened and did not apologize to her.
Chad, please.
According to the defendant, did Jason Mangle ever come home?
He did.
When did that occur in relation to the physical contact as stated by the defendant?
Shortly after Jason came home.
Did the defendant tell you whether or not she told Jason what she claimed happened?
She did not.
She did not tell you, or she did not tell Jason?
She did not tell Jason.
Did she say why she didn't tell Jason?
She told me that she felt scared and ashamed.
During your contact with the defendant, did you see any bruising or injuries on her?
I did not.
Is that something you would look for given the nature of what was being discussed?
Yes.
Now let's move on to the second incident that the defendant described to you. Where did that occur?
At the address outside the city of Eau Claire.
Whose residence was that, according to the defendant?
John Hanson's.
When did that incident occur?
According to her, a couple days after the first incident.
According to the defendant, how did, was this another incident between John Hanson and the defendant, according to her?
Yes.
How did the two come in contact, according to the defendant?
Ezra was invited to John's residence, and John was the one who picked her up and brought her there.
Did the defendant say why John invited her to the residence?
To talk about what happened.
Did the defendant tell you whether Jason Mengel was around the area during that second incident?
No, she stated that he was off at training.
Was that military training?
Yes.
Did the defendant tell you what time John Hanson picked her up?
Around 7 p.m.
And then he, according to the defendant, drove the two of them to his house?
Yes.
According to the defendant, what did they do when they arrived at his house?
They both started drinking and got intoxicated.
Did the defendant tell you what level of intoxication she was under?
She told me that she got out to be blackout drunk.
Did she say whether or not she got sick?
She also indicated that she was throwing up as well.
Did the defendant tell you if anybody else was home besides her and John Hanson?
She did not mention anyone else.
What does legacy mean to you? Is it the memories you leave?
Trial, because she already been sentenced.
Tell you happened next.
That John brought her out to his room where he then turned the lights off and they were now both on his bed.
Did the defendant tell you whether she was still sick at that point in time?
Yes, she indicated that she was still throwing up at that time.
What did the defendant tell you happened next?
She felt someone laying on top of her.
Was she able to tell you who she thought that person was?
She believed it was John, even though the lights were turned off.
What did the defendant tell you happened next?
That sexual intercourse took place between her and John.
Did the defendant tell you what, if anything, according to her, John said to her during that sexual intercourse?
That he told her to be quiet and to be a good little girl.
Did the defendant tell you that she eventually fell asleep?
Yes.
And did she tell you where she woke up?
She told me that she woke up in John's bed with John laying next to her.
Did she say anything about the clothing that she was wearing according to her?
Yes, she indicated that her socks, underwear, and tights were off on the floor and that she was only wearing her dress.
Did the defendant tell you if John Hanson gave her any directions once she woke up?
She indicated that John told her to leave his bedroom and go to a different bedroom so that his roommate wouldn't think of anything else.
Did the defendant tell you whether she complied with that request?
She did. She said she went to a different room and laid in a different bed.
What did she tell you happened after she laid in that different room in a different bed?
That around 10 a.m. or 11 a.m., John then took her back to Jason's residence.
And that's the 135 Broadway Street address?
Yes.
So this would have been the day after the night drinking at John's house, correct?
Yes.
And does that take us to the third incident as reported by the defendant?
Yes.
What did the defendant tell you happened when she and John Hanson pulled up to Jason Mengel's residence?
That John realized that Jason was not home, and that John told her to go upstairs to Jason's room with him.
Did the defendant tell you if John, according to her, gave her any other directions other than to go to the room?
Only go to John's room and then to take her clothes off.
Did the defendant tell you whether or not she did so?
She told me she did.
Did she tell you why?
She told me because she felt like garbage.
Did she tell you or give you an explanation of why she thought that John did that?
She indicated that John did that because he gets off from it.
Those were her words, similar to those?
Correct.
Did the defendant tell you what John directed her to do, if anything, once in Jason's room?
To perform oral sex.
Did the defendant tell you whether she did that or not?
She told me she did.
And during this incident, is it your understanding that Jason was still on military leave?
Yes.
Did the defendant tell you whether or not she and John Hanson had sexual intercourse in Jason's room?
She told me they did.
So she telling you everything.
Did she tell you whether, according to her, John Hanson wore any protection?
No protection was used.
And did she say whether or not John Hanson ejaculated inside of her vagina?
She told me he did.
Did the defendant tell you whether or not she either fought off John Hanson or told him no?
She told me she did not.
How did she describe what John Hanson had done to her?
She indicated to me that he used me.
After the sexual intercourse occurred, did the defendant tell you where John Hanson went, if anywhere?
Yes, John went to a coffee house called Racy's to get coffee.
Did he ever come back, according to the defendant?
He never came back.
Did the defendant remain at Jason's apartment while
Thank
John Hanson went to
you.
get coffee, according to her?
So sweet.
What did she say that she did in the apartment after John left?
She indicated she went to autopilot mode and remained in that residence.
And autopilot were those words that she used?
Yes.
Did she say whether she took a shower and got dressed?
Yes, she indicated she also took a shower and got dressed.
Did the defendant tell you whether or not she had continued, or whether John Hanson had text messaged her subsequent to the incidents we've talked about?
He has.
According to the defendant, what did John Hanson tell the defendant to do, or if anything?
To erase the text messages that he's been sending her to protect him.
I'm going to make a bold statement and say that doing it text on is going to
So asking a lot of questions.
transformative and
Goodness gracious.
She told me she did.
Watch the video theater.
But okay? Okay. It's not unusual. You've investigated domestic abuse incidents before? I have. You've investigated sexual assault incidents before, correct? I have. It's not unusual in those incidents for there to be no
witnesses other than the two participants.
Objection relevance.
Goes to relevance. I can follow it up here quickly.
Well, I'm an overrule. Go ahead, Mr. Nelson.
They're saying your experience that they're typically not witnesses to those events. Agreed? Yes. Do you know this gentleman over here to my left with the blue shirt and the black tie sitting behind the prosecution team? I do. That's Investigator Proc. Yes, he is. He's somebody that works in your office. Correct. And you're aware that after you conducted this initial fact-gathering interview, eventually Ms. McCandless met later on with Mr. Proc. Is that right? I'm not asking you the content. I'm just saying that you're aware of the fact that those two met to speak about the same incident that she spoke to you about. Not right away, but eventually, yes. As you sit here today, you're aware.
Eventually, how you know?
And what Ms. McCandless described about the first incident was and I know it's, I'm just trying to get into the context, time when she says John Hanson put her hands on her throat or a headlock, right? Yes. Are you aware that upon further investigation, the Eau Claire Police Department determined that there wasn't actually a witness to that event other than John Hanson and Ezra McCandless? I did not know that.
Somebody coughing in the courtroom.
About how she responded in all three of these incidents, correct? Yes. And she described a situation in which there was no weapon involved in any way. Agreed? Agreed. She said that she never said John had a knife, did she? She never did. She never told you that she thought her life was threatened, did she? She did not. She expressed to you in describing what was happening, or you asked her questions about her not reporting it, is that right? At least to her boyfriend or to others. Yes. And she expressed to you her feelings of shame, right? She did. And again, that's not unusual that you've heard that when you speak with other victims of these types of events. Agreed? Agreed. She responded to you at one point that she, quote, thought I was a piece of garbage for going to his home. Is that right? Yes. And at another point, she expressed to you, quote, I let him use me. Is that right?
I'm gonna object cumulative.
Sustain. Or you can't repeat everything, Mr. Nelson. We have a time limit, and
He
we have
did.
to keep this moving.
He is repeating everything that man other attorneys said.
Same question multiple times.
He sure is.
Don't believe he has. There's three specific
Okay,
quotes that I want.
just move on. Just move on.
One of the things that she expressed that she was upset about that hasn't been asked about was she told you that he's telling everyone there wasn't sex. Agreed? Yes. Do you know if there was any additional investigation later to determine whether eventually John Hanson changed that and admitted to having sex or not? I'm not aware of that. At the when you were briefly, she told you at the end of all of this, at the end of the third incident, she went into what she said was shutdown mode, right? Correct. She used the term autopilot. Yes. And again, that's not unusual based upon your training and experience that you've had with other victims of assault to express a similar type of feeling. Agreed? Yes. That's all. Thank you.
All right. Any redirect?
Briefly, Judge. Officer, it was a bit hard to hear the recording. Would you agree?
Yes.
And the testimony that you provided, either if it was hard to hear or if it was outside of that part that was played, your testimony was consistent with what you saw in the video and the additional portion that wasn't played, correct?
Yes.
You mentioned that there were some questions about resources and information that was provided by two women who were part of a crime victim response team to the defendant, correct?
Correct.
So that information was, as you stated on cross-examination, information that let the defendant know there were resources if she was in a situation similar to this one that she described, correct?
Yes.
Yes.
So if she was being interviewed by a male and she wanted to speak with women, she could have relied on those resources, correct?
Objection. We approach.
Objection overruled.
Oh,
The
Judge.
question,
Can you repeat the question?
the information, there was information provided by two women from a crime victim response team to the defendant, correct?
Yes.
And that was information about resources that she could call if she was in a situation similar to this one in the future, correct?
Objection. No foundation. He doesn't know what they told her.
Overruled.
Yes. And you have experience with the crime victim response team in your employment, correct?
Yes.
So you're familiar with the general type of information that they provide?
Yes.
So the information that was provided on February 26, 2018 to the defendant provided her with resources that she could have relied on if she was in a similar situation or being interviewed by a male or somebody else in the future. Is that correct?
Yes.
Nothing further.
Right, any recross?
Just this issue about what resources were provided. When she met with the victim crisis response team, you weren't in the room, were you? No. You don't, other than through, if you watched the recording at the time, you didn't know what was told to her, correct?
Correct.
When you conducted the interview, you didn't tell her, hey, if you want a female officer in here, you can do that, correct?
Correct.
And she acknowledged that she was okay speaking with you, correct?
She did.
But you never availed her of this apparent opportunity that the state was alluding to. She could ask for a female officer. You didn't tell her that, correct?
Correct.
You don't know what, if anything, she did with follow-up with people from the victim witness or the crisis response, do you?
I do not.
You don't know if she went to Bolton House Refuge and spoke with people there.
I do not
I
know.
don't know what they told her.
I do not know.
You don't know if she went to the Chippewa Falls Family Wellness Center and spoke with people there.
I do not know.
You don't know what they told her.
No.
And you certainly understand that any human being who has suffered from trauma may or may not be able to avail themselves of all the opportunities for help. Agreed?
Correct.
Agreed.
Sometimes when people are suffering from that trauma in the moment, they can't necessarily ask for the help that they need, right?
Objection calls for speculation.
Yep.
Sustained.
Well, there's this implication that you gave in your testimony that a woman who's been assaulted once should know in the future what she needs to do during some future assault. Is that what you're saying?
Objection, that misstates the testimony and it's
Sustained, agreed.
That's certainly not what you're implying, is it?
No.
Repeat the question.
You're not implying that because a woman was assaulted one time, that they would absolutely know how to respond if that ever occurred in the future.
objection asked and answered, speculative.
All right, I've already sustained the objection on that. So,
Can we approach, Judge?
no, I don't think we need to approach on that.
Ooh.
So, if you would wrap up your recross.
No, Judge.
Question.
First,
That's tripping.
handless by crisis response workers. Agreed? Agreed. You don't know what was told of her. Agreed?
Agreed.
That's all.
Okay. Officer Bang, I believe you're free to go. Anybody intend to recall Officer Bang? No. Okay. You're free to go, sir. Free to step
You
down.
better get up. Get up and run out of there.
Have a good day.
He's still sitting there.
Okay, ladies and gentlemen, we're going to be for lunch. Our break. So, all rise.
She was 26 years old. Let me skip it, guys.
This most recent series of objections, as well as a sidebar. Mr. Nelson, why don't you go ahead? You can make a record as to what it is that you wish to elicit and why. And then Mr. Hahn will have an opportunity to, I guess, make a record as it relates to his objection.
Judge, on redirect, the state asked questions getting into information that the witness said he didn't know about. I objected, talked in general terms about it. I said once they go into that, I should have the opportunity on recross to then speak about that same subject in a manner in which he would know or how a person was supposed to respond. The state went into that. I tried to ask those questions. I was shut down from asking those questions. I think it's relevant information. The state made
Ooh, get him.
that left an impression from this witness that a woman who has been assaulted would be able to or should know or needs to respond in a certain way in the event of a second assault or in the event of an investigation of a second assault. It was not clear how that was done on redirect. I was trying to clarify that. I was trying to follow up on
Look
that.
at the judge. Why you holding your head down?
That witness was cut off. I appreciate Your Honor's ruling, but I'm just making a record. I believe that it was impermissibly cut off, that I should be allowed to cross-examine that witness on what he did and didn't know, and what to clear up any negative inference or any implicit argument that the state, I think, was making, in which a woman who's been a victim first needs to respond later on in a particular manner.
Okay, Mr. Hahn.
There's been a lot made about whether or not female officers should have been involved in the interviewing of Ms. McCandless, including through this witness. And I was simply making that point that resources were made available to her. And when I thought that defense
Why he sitting down?
scope of that questioning and was entering a place of speculation as to what sexual assault victims in general are required to do or consistently do, I objected.
Just so it's clear, I never made any reference to female officers. I never said anything about a female officer. I laid out the facts. And the facts was eventually 2 women from victim witness came there. I didn't say why weren't they there before. I didn't leave any impression that there should have been women. I didn't ask him about female officers. I never went there. That wasn't a part of my cross-examination in any way, shape, or form. I laid out the facts that he spoke with her, Jason Mandel spoke with her, and then people from the crisis response team showed up. No implication about Larry.
Judge, if I could just be brief on that. There's certainly an implication in the context of the other witnesses that have been cross-examined by defense counsel, and the emphasis on, and then 2 women showed up to speak with Ms. McCandless is certainly at least implying that there was an issue with the gender of the officer conducting the interview, or at least that there should have been a possibility of a woman being involved.
But the question that was then asked was, does Ms. McCandless, would she have known she could ask for a women officer? And that wasn't part of my cross. And there's no
That's right.
basis for them to ask that question when we don't know what the victim witness people told them. We don't know what
That's right.
We don't know that they ever said, hey, if you're ever being interviewed by a male, you can speak with a female officer.
That's
She didn't
right.
speak with a female officer. She wasn't offered that. She spoke with other females about other matters that weren't part of the investigation, that were part of the support. So I think that misleads, misconstrues what the evidence was.
All right. Well, in the sidebar, you mentioned also, Mr. Nelson, that this was burden shifting and so on and so forth. And the implication of your arguments has been, going back to this line of questioning, this witness was called to present facts. And you began going into, again, on your, I believe it was your cross-examination into areas about trauma training and so on and so forth. And again, based upon, as Mr. Hahn had indicated, the context of other witnesses, there's this implication or suggestion. Through your questioning, it appears to the court that the Eau Claire officers were insensitive to issues of trauma, not trained in trauma, didn't have a female officer, although you didn't say that. And it just, in the court's opinion, you're getting beyond appropriate cross-examination of this witness and using him for something outside of what he was called for. And in the court's opinion, waste of time, sort of confusing the issues. And the court did not see here that the state was suggesting, or that this witness was suggesting, that this is how a person should react, or in the future, if there was another assault, the officer is simply testifying that resources were provided, that a procedure was followed. They have a crisis response team in a sexual assault situation come in, and he's offering services. And that's all that happened. And I don't think we need to go beyond that. In the court's opinion, it's a waste of time. And we want this officer, again, to be used as part of an overall campaign in this trial about how Ms. McCandless was mistreated because of male officers interviewing her about a sexual assault.
There's no campaign on the defense that Ms. McCandless was mistreating the state. As part of their theory is alleging that Ms. McCandless shouldn't be believed because she didn't initially disclose this. It's the state that is attacking her credibility. And the defense is simply saying, here are things that you should consider. We're not blaming anybody. We're just laying out facts. So we have not been on a, I can't remember what Your Honor just called it, but a campaign.
Well, maybe
Respectfully disagree with that.
perhaps a better term could be used. But this witness, this evidence is, as Mr. Nelson, you very well know, is offered for purposes of the background and facts and circumstances surrounding the weeks that led up to the event on March 22nd, 2019. This is not being received simply to show that this was a false report of a sexual assault. The facts are what they are, and this witness is just a background witness, panorama witness, and so it limited your inquiry into those particular areas on this witness. It's just as simple as that. All right, now that takes care of, I believe, that sidebar, unless there's anything else that you would like to say about that. All right, there was address other sidebars later. I think we're going to recess for lunch. All right.
After lunch, the state had to call Julie Post prior to the jury coming back after lunch. The defense would just like an offer of proof. There's, I think, outside. I don't know what she's going to testify, but certainly her previous interviews have contained lots of inadmissible evidence. Perhaps I'll just discuss it with them, but
Judge, I can move this along. We're not calling Julia Post.
fair enough.
Our next witness will be Jason Engel. We do have some legal issues that need to be sorted out, I think, relatively quickly. Attorney Bishop is handling that. She's not here, so we can meet with her briefly over lunch and finalize exactly what we have to address, and we'll bring it to the court.
Very good. Okay, we'll be in recess until.
Sorry, just two more things. COURTTV stopped me. They want a copy of the journals. I told them to talk to the court about it as well. We haven't discussed the cautionary instruction regarding this other act's evidence. I'll leave it to the court as to just wanted a reminder that I didn't know when you were intending to instruct the jury regarding, it contains some information relating to the John Hanson matter, so I didn't know when Your Honor was going to, or if and when Your Honor was going to give a cautionary instruction.
Well, the cautionary instructions for the jury, not necessarily for those who are watching a public trial. Those exhibits are public exhibits and exhibits. Well, okay, so I'm sure that the counsel will be referring to these exhibits and the content of these exhibits in closing arguments. So, all right, we're in recess until 1.
He's not giving them an answer. He's something else.
Okay. You'll have a moment. I have a couple of things back on the record. Okay. During the break, learned that there's a request from the media for the exhibits related to the journals that were sort of privately published to the jury, and specifically exhibits 365 as redacted and 366. And court was anticipating that to be published by the state through the media presentation, and it was not. There were copies of that exhibit, both exhibits provided to the jury. But in the spirit of Wisconsin Statute Section 757.14, which requires the sitting of every court to be public, as well as the state of Wisconsin or State Ex Rel Lacrosse Tribune versus Circuit Court for Lacrosse County case, that's reported at 115 Wisconsin 2nd 228. It's a 1983 case. In the court's opinion, and just sort of a personal editorial, one of the reasons that I pressed more confidence monitors in courtrooms and screens was because if those attending or the media can't see the exhibits, then it really isn't a public trial. There are reasons to keep some things from public view for avoiding undue embarrassment or humiliation, or there's frankly some inappropriate content. Specifically, those exhibits with showing the private genital areas and so forth in the folders. That's not going to the media. I think that is appropriate. I think it was described. There were drawings. However, the court believes that those exhibits I've just referred to, there's no reason that they should not be provided to the media. We're not going to be in a position to honor public records requests generally during the course of this trial, but because the media does hold a special place recognized in the law because they are reporting on behalf of the media, on behalf of the public, the court is going to order that those exhibits be provided to media covering the trial if they request. There's also a request for the exhibits related to the DNA analysis. As it relates to those exhibits, we have not yet come up with a redaction. My thoughts at this point in time would be that if on Exhibit 554, which contains the portions where there was considerable argument and a stipulation, that the text in those sections and the corresponding letters or item numbers, that essentially that area be whited out and the word stipulation be put in its place. And I just want counsel to think about that, but I'm not going to have those exhibits released until we do come up.
Your Honor, there's a number of other tests that were done on other items that were submitted for evidence that were not brought up, they're not relevant to this case. Listing your house on the market.
Yeah, they had to wait late to do this one.
Final item should also be redacted once not.
Because this has come up on short notice, but give the parties an opportunity to think about that overnight in terms of appropriate redaction for those exhibits. But I believe that those parts of the exhibit that were received in evidence in one way or another will be provided to the media with appropriate redaction. But we obviously don't have time to do all that right now. We have to keep the trial moving. And so, are we ready for the next witness?
We have a couple legal issues that we need to address before
All right.
Mr. Mengel's called. First, I just wanted to let the court know, I think there was a misunderstanding of what Attorney Nodoff was mentioning prior to our. It was mentioned in the context of COURTTV. There were two separate thoughts, however. The cautionary instruction was whether or not an instruction should be read, because we just heard some what would be considered other acts evidence. But as long as it's on the court's radar, I know we haven't sorted out what exactly the instruction would be. I think the state is fine having that read later as part of the broader jury instruction reading to the jury.
All right, Mr. Nelson. Especially. All right. Well, there was some discussion about the cautionary instruction, and obviously, a jury will be given instructions at the close of the case. I have improvised one instruction basically as it relates to what evidence is, so they would have some idea of that before the court advised them of stipulation and judicially noticed facts. However, we've now gone into what would be considered other acts type of evidence, and panorama evidence is sort of a special part of that. It's a little bit different. The same analysis I think applies, but no cautionary instruction has been provided to the jury why they're hearing that evidence. Just the defense request that there be instructions at the close of the case.
Not right now.
All right, and that's something we'll take up.
However, at a later time, I haven't. Did you provide us with a draft of what you wanted?
No, and we have not. It wasn't something we were pushing to have done now. I just wanted to make sure that the court was aware of it. So defense.
Very well. So that's just to give you a heads up that we will take that up, and I think periodically it's not a bad idea to do that so that they get some understanding of why they're hearing that evidence.
Judge, I just need to talk to. I'm a little confused about something. If I can just talk to Mr. Hahn for a minute.
Go ahead.
Objection on the record. I apologize. I feel like I might. Mr. Hahn was kind enough to give me some exhibits in advance that he's going to use. I'm not seeing them, so I asked Mr. Maxey to see if I left them in the other room, Judge. But regardless, I can put an objection on the record or ask for a ruling right now on another matter, which is the state has advised me that it intends to introduce various things that were. The state intends to use various pages of screenshots that I believe, and Mr. Hahn should correct me if I'm wrong, there are some screenshots that Jason Mangle took of Ezra McCandless's iPod or of her Instagram account, no matter what the device was. And the state intends to enter them as an exhibit. I don't know if there's. Are these numbers on the bottom of the page different exhibit numbers for each?
Yeah, 473 through 476.
Correct. And I think what I'll do is just give them to Your Honor to look at for a minute so you can see what I'm talking about.
Okay, so these are sort of hand numbered. They have the number.
They're hand numbered with the exhibit numbers that the state intends to introduce. So basically what this is that my understanding is that Mr. Mangle looked at Ezra McCandless's Instagram and screenshotted these from her Instagram.
Oh.
The people who are purportedly talking on those Instagram pages, as I understand it, are John Hansen and Ezra McCandless. And this content, which is on there, can best be described as flirtatious. I'll just use that word for right now, between Ms. McCandless and Mr. Hansen. And I am objecting to the relevancy of the
those messages that were between these two individuals. First of all, as to Mr. Hansen, the state has chosen to not call Mr. Hansen. I've been told he's not being called as a witness, possibly in rebuttal, but not in the state's case in chief. So anything that Mr. Hansen says is hearsay. Now, I'm going to anticipate that the state is saying that they are only introducing Mr. Hansen's statements in order to give context to Ms. McCandless' statements. Therefore, I continue my objection to argue that Ms. McCandless' flirtatious statements toward John Hansen do not belong in this trial in the state's case in chief. The court has ruled that Ms. McCandless' sexual conduct with Mr. Hansen is permitted as panorama evidence, and we have had evidence of this both through Officer Vang, who took a statement from Ms. McCandless, and I think probably more central to the prosecution's case, the journals Silence Broken and Journal 2, which the state opines is some evidence of Ms. McCandless' emotional turmoil. And as I understood the court's ruling, the court permitted that to be proffered in the state's case in chief as evidence of Ms. McCandless' state of mind, emotional turmoil, and panorama of the events leading up to Alex Woodward's death. However, her specific flirtations with John Hansen and her comments do constitute other acts of evidence. My understanding is that the state attempted to proffer these in its case in chief as some kind of evidence that Ezra McCandless was not truthful about what she said to the police about what happened sexually between her and Mr. Hansen. My understanding was the court was not going to allow evidence to be elicited for its purpose of arguing that Ms. McCandless was not credible or purportedly had made some kind of false claim of sexual assault to the police. So I can't frankly grasp what is relevant about her flirtatious texts to Mr. Hansen, which were screenshotted by Jason Mangle, how that helps to prove or disprove a fact and issue in this particular case. These are matters between her and Mr. Hansen, this flirtation. This has nothing to do with what happened between her and Alex. If the state is arguing these go to her credibility, she hasn't testified in this case at this juncture, and they simply should not be permitted into evidence. That's my argument.
Okay, who would like to handle that argument?
I will, Judge. First, as to the hearsay, they're not being offered. Mr. Hansen's statements are not being offered to prove the truth of the matter asserted. So I think that's pretty clearly not hearsay. If the court finds that it is being offered for the truth of the matter asserted, those are adoptive admissions by the defendant by acknowledging and responding to the statements that are made by Mr. Hansen. And really, it's this is a segment of what was included in the state. The defense filed a motion in limine trying to exclude all of the messages contained on Mr. Hansen's or provided by Mr. Hansen as it relates to his relationship with the defendant. These are only a portion of those because this is what was pulled from Jason Mangle's phone, not the entirety of the messages John Hansen provided. The court has found that the relationship between the defendant and Mr. Mangle, as well as the defendant and Mr. Hansen, is relevant to this case for certain purposes. And these messages are how Mr. Mangle came to be aware of the relationship between the defendant and Mr. Hansen when he observed these and then screenshotted them on his phone. They were initially observed on her phone, and that's why he saw them and took photographs. The messages come after the believed date of the sexual encounter that we've heard a little bit about, and I expect there will be more testimony about, between the defendant and Mr. Hansen. So I think it shows it's relevant for a number of purposes: state of mind, the relationship between the defendant and Mr. Hansen, but more importantly, the relationship between the defendant and Mr. Mengel, and the information she provided Mr. Mengel, and how that meshes or doesn't mesh with the information contained in the text messages. The defense argument that the defendant would somehow need to testify before her ability can be attacked just certainly isn't how court cases work. Credibility of somebody who's provided statements, a defendant who's provided statements to law enforcement or anybody else prior to trial, and those statements are being admitted, those statements can certainly be attacked on the credibility basis. So she doesn't have to testify before her credibility becomes an issue as it relates to statements she's made prior to trial. So I think, one, it's not hearsay. Two, it's relevant. It fits within the provisional rulings of the court. And three, I think the credibility issue doesn't have to be addressed only once she testifies.
Judge, if I can just very briefly respond to the state's argument.
Go ahead.
What I would like to say is, do I think that, for example, her statements that she gave Investigator Kroc, or Detective Kroc, regarding what happened with Alex, that they can show that there are inconsistencies or differences of things she said to him? Yes, of course they can. But this is just for a general attack on her credibility as a person. And that kind of general attack of a witness who testifies for truthfulness may be acquired under 90608 sub 2 upon cross-examination of a witness, and when they're questioned about matters related to their truthfulness as a witness under 90608 sub 2, the cross-examiner must, quote unquote, in the words of Kim Winklery, take the answer. That's a pretty black letter law. So I would argue that these are for a general attack on her credibility, not her statements regarding the alleged offense in this case, the homicide of Alex Woodworth, number one. Number two, if the evidentiary purpose for the state is to show that this created a fissure or a problem in her relationship with Jason Mengel, which was part of her state of mind, which is what the state argued in its opening, then all the state has to do, and I would not object to them leading, is say, you read her Instagram, there were some things that upset you. Through reading this Instagram, you believed that your girlfriend had sex with your friend John, and the two of you were arguing about this, and then this is what she told you happened. The substance of those actual messages, which again I argue are not relevant to anything except for Ms. McCandless's credibility, in which case she can be cross-examined, but there are extrinsic evidence on a collateral matter should not be permitted into evidence. Thank you.
All right. Well, first of all, I do not see these exhibits as being 608 sub 2 extrinsic evidence. And this is not where witnesses being cross-examined on credibility. And they're not, as the court made clear in the provisional ruling, not offered related to credibility. And however, I did say that if this panorama evidence comes in, it may have the effect, but that's not the purpose for which it's offered. Now, we have in this case already, and I'm not going to comment on what evidence may come in because it hasn't come in yet. But at this point, I think we have evidence that Ms. McCandless went to talk to Mr. Woodworth on March 22nd about her feelings. She went, and I think this came in through one of the officers, perhaps Officer Reeves. One of the things she wanted to talk about was the investigation, and the name John Hansen had come up. And the court believes that these messages are very relevant. And in particular, when you look at exhibits, journals, silence broken. Exhibit 366, Journal 2. In both of those exhibits, there is reference by the defendant to pain, regret, disgust, shame, waves of guilt, and from exhibit 365 in particular, on the second to last page, makes reference to the extreme guilt. I'm quoting, the extreme guilt I felt because of the betrayal I had committed against the love of my life drove me to start self-harming again. I think in a nutshell, these messages are at the heart of that, and without a jury seeing the actual messages in the court's opinion, it's difficult for them to understand the context, understand the significance of exhibits 365 and 366. So again, these in the court's opinion are very relevant evidence to those very strong feelings that Ms. McCandless had. And I think that they are very relevant. I do not believe that we are per se not offered for the truth of the matter asserted in the sense of what Mr. Hansen said, but certainly for what the defendant said as her statements. And so the court is going to allow exhibits 473, 474, 75, and 76, assuming that's what the actual exhibit, that will be the numbers, Madam Clerk. So these should be marked as an exhibit since I'm referring to them. Otherwise, we're going to be.
Judge, I think the stamp at the bottom, it's very small, but it actually does have the court's.
Well, it has someone wrote handwriting the numbers, but we need exhibit stickers to correspond so that we're not.
It's very tiny above it. It says plaintiff's exhibit. I certainly think we could. I'll leave it to the clerk, obviously. But
Okay, well, we would like to have our court exhibit stickers on these.
Those are my copy though.
Okay,
I'm
so,
assuming the state has another copy to give the court.
well, I want to make sure that what I'm referring to, I have in my hand.
That's right.
Is exactly the same as the those court exhibits. So,
Judge, I can give a separate copy to Attorney Bishop if you want to keep those as what will be marked.
That would be fine. That would be fine with me.
and there are numbers on.
Obtaining his PhD and becoming a professor in philosophy and writing about philosophy upon hours reading books, reading different philosophy books, and writing about those interpretations in his journals. In fact, those journals will be used since trial in an attempt to show that the defendant was afraid of Alex. However, when you don't take bits and pieces out of context, when you read the whole journals, you will realize that these are philosophical musings of a young man who wanted to be a philosophy professor. And in fact, the evidence will show that it was the defendant who sought out Alex on the date of his death. Not once, but twice that day. Alex spent most of his days at Racy's coffee shop in Eau Claire. Some would say it's the place he felt most at home, where he felt safe. He was going to Racy's through college. He would sit there all day, reading books, drinking coffee, writing in his journals. Most of his friends were from the Racy's crowd, and he also worked at Racy's coffee shop. Unfortunately for Alex, that's also the same place where he met the person who would later take his life. The defendant and Alex met in October of 2017, and shortly thereafter began dating. Also, unfortunately for Alex, the defendant
a series of other relationships. At the time, she was involved in a relationship with Jason Mengel, and later she was also involved in an intimate relationship with John Hansen. You will hear information regarding these relationships throughout this trial in the months leading up to Alex's death. And the reason why you are hearing these is to gain insight into the defendant's state of mind and what drove her to her actions on March 22nd. In February of 2018, Jason Mengel learned of the defendant's relationship with John Hansen. He learned that while he was away from military training, the defendant had an intimate relationship with his good friend John Hansen. He also learned that the defendant had an intimate relationship with Alex. And Jason Mengel confronted the defendant about that. And she responded by saying that Alex had taken advantage of her. And after these relationships came to light, the defendant's relationship with Jason Mengel ended. And the defendant's life began to spiral out of control. She had to move back to Stanley, Wisconsin, a place she did not want to be. She had to live with her parents, where she was away from the art scene in Eau Claire, away from her friends at Racy's coffee shop, and most importantly, she was away from the love of her life, the love of the man that she was truly obsessed with, Jason Mengel. In her journals, she describes her relationship with Jason Mengel as an ancient love so powerful that it scares them both. The defendant then began to blame Alex for her relationship problems with Jason Mengel. And around February 24th of 2018, the defendant sent a message to Alex instructing him to not talk to her ever again. And Alex obeyed that demand. From February 24th to the date of his death on March 22nd, there was no communication between the two of them. Instead, it was the defendant who sought out Alex. In an interview to law enforcement, the defendant was asked, what was so important that you had to see Alex that day? And she explained that she had a heating pad and a bookmark that she had to return to Alex. And despite returning those items to Alex, she insisted on going someplace in nature to talk. You will hear that the defendant's acts on March 22nd, 2018 were particularly unusual. I have a timeline of events to show you, and I realize it will be hard for you to read these, but it's more of an aid to help me, but you will be able to at least see the pictures. So on that day, the defendant ends up taking her car, despite being specifically told by her dad not to drive, and despite her dad hiding her car keys. She takes her keys, finds her keys, and somehow drives to Eau Claire. And she is seen on the traffic cameras in the city of Eau Claire in an area near Alex's apartment at 10:43 a.m. She's seen again at approximately 10:50 a.m. And law enforcement were able to identify the defendant's car, as it's rather distinctive as it has a number of drawings on it. At approximately 10:53 a.m., she arrives at Racy's coffee shop. And when she arrives at Racy's coffee shop, she sees Jason Mengel before she goes inside. And Jason Mengel will later tell you that he sees a fire in her eyes. The defendant then goes inside Racy's coffee shop, buys a cup of coffee, and leaves a tip. While for most defendants that wouldn't be unusual, for this defendant, she very rarely paid for her coffee. She either got free coffee or got someone else to buy it for her. And she certainly never left a tip. The
person serving her coffee that day described her appearance as different and that she was disheveled, she wasn't wearing makeup. The defendant then leaves and goes to Max Martinson's house to do some sort of art exchange. And then she comes back to Racy's. And during this time, her ex sort of boyfriend, they were on shaky ground, gets particularly concerned. He recalls seeing this fire in her eyes, and he has a bad feeling. He also realized that the defendant had been doing some journaling about feeling taken advantage of and feeling like she had been assaulted. Jason also remembered that the defendant said that she felt like her voice had been taken and she wanted to get her voice back. So Jason Mingle, he gets concerned and he decides to go on his bike and he starts to head to John Hansen's house. And as he goes to John Hansen's house, he remembers, oh no, John Hansen moved, so he goes to Alex's house. So he rides his bike to Alex's house, and when he arrives, he sees the defendant's car in the driveway at Alex's house. The car is running, the door is open, and music is playing. Jason Mingle gets concerned again. So he decides to go sort of across the street from where Alex's house is. He's sitting at a picnic table, smoking some cigarettes, and then he decides, I'm going to just go in Alex's house. So he goes in Alex's house and learns that everything's okay. And as he's exiting Alex's house, he is confronted by the Eau Claire police. So a janitor who had watched Jason Mingle while he was smoking some cigarettes thought this was unusual. So the police come, and Jason Mingle describes to them, this bad feeling, the fire in her eyes, and then the police go and talk to the defendant and Alex. And the defendant specifically tells the police everything's fine. She doesn't mention that she's afraid of Alex or fearful of Alex. And so the police leave, and the defendant leaves Alex's house at approximately 1:05 p.m. The defendant's in the driver's seat, and Alex is in the passenger seat. Alex would never be seen again. At approximately 1:25 p.m., Chester Davidson, a man who was driving to work on 430th Avenue, describes seeing a vehicle at approximately 1:25 p.m. blocking his lane of traffic, such that he's traveling on 430th Avenue and he needs to kind of weave around this vehicle. And he describes seeing a female in the passenger seat, a female in the driver's seat, and a male in the passenger seat. It's not until 3 hours later, or almost 3 hours later, at 4:15 p.m. that the defendant is seen again. So let's take a look at what this nature location was where the defendant took Alex that day.
Defense attorney looking rough.
This was a narrow field drive in a very rural part of Dunn County, a place where no one could see or hear what was going on. So approximately 4:15, well, what happens between those 3 hours? From 1:25 to 4:15. The defendant brutally stabs Alex, takes the knife she used, takes Alex's phone, and goes to Don Sipple's house, about a half a mile away. She ditches the phone and knife, though, before she goes and sees Don Sipple. And she makes contact with Don Sipple and asks him to call a doctor. Well, Don Sipple decides to call the police. And when the police arrive, the defendant can provide very little information. She's eventually able to provide her name as Monica Carlin. She's able to describe that she's been attacked by an unknown person or persons. She can't provide much other information than that. But when asked if there's anyone they can call, she's able to say the name ambulance to Mayo for an evaluation. And during that evaluation, she's examined from head to toe for any injuries. And the injuries that Dr. Tillotson, or wounds if you want to call them that, I guess, that Dr. Tillotson observes are some scratch marks on her left forearm that have the words B-O-Y carved into her arm. On her left palm, 3 slight superficial lacerations or scratches on the palm of her hand. On the right outer thigh, 3 linear scratches, or not 3, but some linear scratches on the right outer thigh. A red mark along her jawline that's not there 2 days later. And some scratches near her underwear or crotch area. Dr. Tillotson describes these as self-inflicted scratches or wounds on the defendant. The defendant also undergoes a sexual assault exam. Pretty long, takes a number of hours for this examination. And during that sexual assault exam, she's again unable to provide very little information. But when asked, how did this B-O-Y get carved into your arm? The defendant states, Alex did that to me. When asked what's the last thing she remembers, she states, being at a park with Alex with a frog statue. Remember that the defendant states she's right-handed and that the alleged wounds are within arm's reach of a right-handed person. The defendant is then talked to by Deputy Emma Shields and Officer Corey Reeves of the Eau Claire Police Department. She again tells them that Alex carved a boy into her arm, and the last thing she remembers is being at a park with a frog statue. And Officer Reeves from Eau Claire realizes or believes that this is Owen Park. The next day, on March 23rd, 2018, the Eau Claire Police Department gets concerned. Alex is missing. And so Detective Croft goes and talks to the defendant. And during that interview with the defendant, she is less than forthcoming. She's able to describe what happened earlier in the day. And then she's able to describe leaving Alex's house. But after that, she says everything just kind of goes blank for her. She remembers being scared and walking to Don Sipple's house. She has no idea. She makes no mention of stabbing Alex, no mention of Alex being by her car. And so Detective Prock, after that interview, decides to go back to Don Sipple's house. He and some other investigators decide to be proactive and try to find Alex. And they see that narrow dirt road. And as they go down that dirt road, they see Alex's body hanging out of the back of the vehicle. And so Detective Prock decides he's going to go talk to the defendant again. So they begin their interview, and Detective Prock asks about the defendant's relationship with Alex. And the defendant describes that they were friends, and then their relationship turned sexual. And even though it was consensual, a consensual sexual relationship, it just felt wrong to her. She's unable to provide some information how Alex was calling her the wrong pronouns, where she used to have more, or I guess we qualify more masculine pronouns, but now she was identifying with more female pronouns. But Alex was continuing to use the masculine pronouns. And then Detective Prock asks her again about the boy, B-O-Y, carved into her arm. So let's take a listen and see what she has to say about that.
pronouns that weren't my pronouns. I used to go by my neutral pronouns in high school and more masculine pronouns. I talked to her briefly about it, how I was kind of going through identity things. But now I go by her pronouns because that's how I feel comfortable. But he kept using their he pronouns because he preferred it. And he used to call me boy a lot, stuff like that. And I was just kind of like, I don't really identify that way anymore. Because like I identify feminine and stuff because in the past I just kind of was more masculine for having self-protection.
And so, so this gender is all handed out in this year? Or, I guess the way you describe it is like over your arms.
Yeah.
Something happened. What happened there?
I remember like that's when my anxiety got really bad because I remember just kind of being really uncomfortable because I don't like when people grab me. I remember just kind of like being grabbed and then it just kind of like the anxiety went crazy, like completely through the roof. The anxiety went up. And then sometimes when that happens, it's just like everything goes black for a while.
So, where were you when you were grabbed?
I was in the car.
And how did he grab you?
Grabbed me by the arm, like right there.
Where was he?
He was in the passenger. He was in the driver's seat. I was in the passenger. I don't know if I think we probably were parked. I think it was before we started driving again. And it was just because I remember it happening, like being grabbed, and just feeling hurt and anxious, and then it just starts getting really, really dark, fuzzy for me. Just feeling so anxious.
And so how does your arm get cut up?
Alex, like, he grabbed it, and then he kept telling me about being a boy and stuff like that, how frustrating it is. He, like, threatened me.
What do you mean he threatened you?
He didn't say he was gonna do something, but he grabbed me and started doing something.
What do you mean he started doing something?
He started like carving something in my arm.
Where is this? On your arm?
His arm.
Can I see?
Uh-oh.
After that conversation, Detective Croc asked the defendant, I know you had a sexual assault exam. Do you believe that you were sexually assaulted? And the defendant responds, well, she doesn't know. So she just...
So, one other question I have is, after this incident, did you do anything to yourself?
And so he asked her about, do you think you were sexually assaulted? And the defendant says, well, I don't know. I just thought that maybe I was sexually assaulted because my pants were cut near my crotch area. And then Detective Croc confronts the defendant. He tells the defendant, we found your car. And I think you know what happened. And the defendant responds in the same interview, yeah. The defendant is unable to say and provide a detailed explanation of the stabs that she made on Alex's body, the different locations, as well as a detailed description of the sequence of events that happened that day. And then Detective Croc asks her, "Car's boy in your arm?" So let's listen to what she says during this time.
One other question I have is, after this incident, did you do anything to yourself? Did you harm yourself in any way? You said, well, what happened?
I didn't harm myself.
You didn't?
No, when I fell, I hurt my hand and I bit my tongue.
Okay. And then, the boy hurting your arm. Okay. The part that throws me off on that is, if I'm sitting here, he's going to be carving it in. It's written perfect with a right-hand person like this. Okay, if he would write it in,
day or have sex with you. And the defendant says, no. I just think he wanted to look at me.
What? Weird.
Ladies and gentlemen, this was not a knife fight, as the defendant would like you to believe.
Oh.
The defendant used this knife, a knife she had taken from her dad's house within days before Alex's death. A sharp EMT knife. And she took this knife and she brutally and forcefully used the knife to stab Alex in the back of the head.
Oh.
Through the scalp, through the right temporal bone, into the brain, piercing the brain. She used this knife to slit him across the throat 3 times on the right side. She stabbed him 3 times on the left side. And if that wasn't enough, she brutally stabbed him 3 times on the left side of the chest, with one of the blows piercing Alex's lung. She stabbed him in the back right of the shoulder, and she stabbed him in the back, also piercing the lung. And of course, she stabbed him in the genitals, piercing the scrotal sac. Ladies and gentlemen, this was not anger. This was rage, and this was personal.
Honey, this is too long. Yeah, what I'm gonna do is I'm gonna start right here with the finish up with the opening statement. I didn't know the opening statement was gonna be this long. Good jeez. So what we'll do is we'll finish it out tomorrow. Okay, we'll finish the opening statement out tomorrow. Cause they long. See, she already convicted, y'all. She already charged everything. She already charged. She just want them to retrial her. That's what she want. Wait. Y'all, thank you for being here. I'll see y'all tomorrow. I got another video coming on at 5. I'm out.